Hello friends, in this video I am going to discuss what is plea bargaining. However, before explaining the concept of plea bargaining, I would like to quote here the wonderful statement given by Abraham Lincoln, the 16th President of the United States. He says, "Discourage litigation. Persuade your neighbors to compromise whenever you can. As a peacemaker, the lawyer has superior opportunity of being a good man." So, this quote is integrated the concept of plea bargaining because the fundamental meaning of plea bargaining is to end the trial. Now, let's start with the definition. As defined by the Black's Law Dictionary, the plea bargaining is the process whereby the accused and the prosecutor in criminal case work out a mutually satisfactory disposition of the case subject to the court approval. It usually involves the accused pleading guilty to a lesser offense or to only one or some of the counts of a multi-count indictment in return for a lighter than that possible for the graver charge. Furthermore, to clarify this definition, now we take help of Oxford Dictionary. According to this dictionary, plea means appeal, request, prayer, or a formal statement. And the meaning of bargain is negotiation, deal, covenant, barter, settlement, etc. So, it is basically negotiation to settle the case at early stage. Better to say before starting the trial. Now, the next point is salient features of plea bargaining. Based on the above definition, following are the significant features of plea bargaining. Disposition of the case on mutually agreed terms, a possible concession in sentence or and charge to accused or culprit by the prosecuting authority, and the negotiation must be done under the judicial purview. Next, what are the types of plea bargaining? Plea bargaining, broadly categorized as charge bargaining. Prosecutor accepts the lenient charge by the dismissing the higher or other charges on the acceptance of the charged crime by the defendant. Next, sentence bargaining. In such a case, with the consent of the prosecutor and victim, the accused pleads guilty for a lesser sentence than prescribed for the particular offense. That is, if the punishment for the particular crime is 1 year, then it may be 9 months or even 6 months. The third type of plea bargaining is also there, that is fact bargaining, but it is very less in use. Next, who can file an application for the plea bargaining? All those accused who is 18 years or above old and his trial is pending can file an application for the plea bargaining. Note, the offense must be of such nature that its punishment is less than 7 years. Now, the next question is, when can we file an application for the plea bargaining? Normally, an application for the plea bargaining can be filed just before the commencement of the actual trial of the case. However, it can be filed at any point in time during the pendency trial of the case. Now, the next question is, what are the benefits of plea bargaining? Plea bargaining is beneficial for both the parties, the prosecution as well as the defendant, as it is time saving, money saving, and guaranteed swift solution. Furthermore, it protects from physical as well as mental harassment, as court proceedings are very lengthy, time-taking, and expensive and cause mental, physical, and financial harassment. Now, let's talk about some exceptions. What are the cases? Those are not included in plea bargaining. So, in the following cases, plea bargaining is not applicable. Offenses affecting the socio-economic condition, such as the Commission of Sati Prevention Act 1987, the Dowry Prohibition Act 1961, the Immoral Traffic Prevention Act 1956, the Army Act 1950, the Explosive Act 1884, the Protection of Children from Sexual Offences Act 2012. Now, exceptions are continuous. That is, according to the Indian Penal Code 1860, the offences under Section 115, abatement of offence punishable with death or imprisonment for life. Section 119, public servant concealing design to commit offence which it is his duty to prevent. Section 302, murder punishment. Section 304, culpable homicide not amounting to murder punishment. Section 304B, dowry death. Section 305, abatement of suicide of child or insane person. Section 307, attempt to murder. Section 376, rape. Section 377, unnatural offences. Section 498, enticing or taking away or detaining with criminal intent of married woman. Section 498A, husband or relative of husband of a woman subjecting her to cruelty, and all other offences which punishment is more than 7 years. Plea bargaining is not applicable for such cases. This is all about the plea bargaining.